Hello, everyone, and thank you for joining. To those of you online and those of you who are in the room here with me, thank you for attending. My name is Krista Wilshire, and I work here at the AgeWell Network Management Office. And on the line with me, I have Krista James, who is the National Director of the Canadian Centre for Elder Law. Krista, do you just want to tab to the next slide, please? So AgeWell partners with 37 universities across Canada. It has over 150 researchers and close to 400 trainees involved in the network. There are also close to 200 community and government partners. Next slide. AgeWell stands for Aging Gracefully Across Environments Using Technology to Support Wellness, Engagement, and Long Life. The vision of AgeWell is to harness the potential of technology to provide high quality and sustainable services and solutions to meet the needs of the current and future generations of older adults in Canada. This means creating capacity for Canada to further establish its position as a global leader in technology and aging. So with me, as I said before, is Krista James, who is the National Director of the Canadian Centre for Elder Law, as well as a staff lawyer. Her work is focused on the legal and policy issues that impact us as we age. Her practice includes legal research, policy analysis, and public legal education involving stakeholders from different sectors. She has written on topics such as abuse and neglect of older adults, mental capacity, age discrimination, and caregiving policy. Increasingly, Krista's work centers on intersections between aging, gender, and the law, and strives to shift narratives on aging from characterizing old people primarily as recipients of care to recognizing older adults in our communities as right-bearing citizens. We are delighted to have her here today for the part 2 of 2 webinars that focus on consent and capacity. Take it away, Krista.
Hello, everyone. Thanks for joining us today for part 2 of our webinar on mental capacity. Crystal, who is still on the line there, is dealing with some of the technology piece. So if you have trouble hearing or have questions, need help with the system, just use the question box on the webinar screen and send her a question, and she will interrupt us and make sure things are working for everyone. So for the first webinar on mental capacity and informed consent aired with AgeWell in May. I'm going to be assuming for the purposes of this webinar that everyone has listened to part 1. But if you have not heard part 1 yet, it is archived on the AgeWell website. Part 1 covers the meaning of mental capacity and informed consent. We also discuss the presumption at law that all people have capacity to make their own decisions. We went over the concept of undue influence, which I'll touch upon briefly again today. We discussed some basic strategies for supporting someone's capacity to participate in decision making. And we went over the concept of informed consent. In today's webinar, I will be talking about accommodation of disability in the context of consent and decision making. I will compare some different capacity standards for different types of decisions or activities. I'll review the fundamentals of substitute and supported decision making and provide an overview of some of the issues in relation to abuse of a substitute decision maker to give you some options if you are in a situation where you have things that you're concerned about. My goal for today, as with the last session, is that you leave this session with a basic understanding of a few complex legal concepts and an enhanced ability to apply these concepts to your work, particularly to identify potential legal issues or problems that require research or advice. I don't expect you to walk out of this webinar a legal expert in the topics that we're talking about today, but the idea is that when you're in situations where some of these concepts come up again, a light bulb is going to go off in your mind at the right times that will identify questions and issues that you need to follow up on. So really to help point you in the right ethical or legal path to get you started. In this presentation, I will go over the legal concepts of capacity, substitute and supported decision-making, and abuse by a substitute decision maker. It is important to understand that for you, in terms of your practice, your particular responsibilities may not be limited exclusively to the law. Your responsibilities could be linked to laws, codes of ethics, and institutional policies. And I want to say a few words about these right now before we jump into the more juicy legal content today. So when I say laws, I'm referring largely to provincial and territorial statutes and regulations, because these tend to be the provincial rather than the national jurisdiction or governments that are creating laws that apply to the areas we're talking about today. The exception being, of course, the criminal law, which is created by the Government of Canada, Parliament. Most laws that relate to capacity are provincial or territorial. One challenge related to this is that the laws may vary slightly and sometimes significantly from jurisdiction to jurisdiction. Different terms are used to refer to similar legal concepts in different provinces. And alternatively, sometimes the same word is used in one province to mean something different in another. This can make things really confusing if your work crosses borders. In this webinar, I will try to stick to legal concepts, so the webinar content will apply to everyone's work rather than highlighting particular provinces or territories. But I will also point out some differences that I think that are important for everyone to understand. In your own work, you'll want to be mindful of what laws apply to your practice or to a particular situation. And if you are doing a national study with participants from multiple provinces or territories, say you are a social science researcher, things might get more complicated for you, so you may want to get legal advice on which laws apply to participants, users, patients, or clients involved in the work you're doing. Now, codes of ethics also matter in terms of your work. If you're a social worker, a nurse, a pharmacist, a physician, a lawyer, another kind of professional, you may want to consult codes of ethics and also practice guidelines that apply to your work and may be developed by your regulatory body. These documents form part of the network of rules and guidelines you are expected to follow in addition to the law. Think of the law as a bare minimum in this regard. Also, please consider institutional policies. So if you work with a university, your employer, another agency you're affiliated with may have created policies that you're expected to understand and apply to your work. As I noted in the last presentation on capacity, my fabulous colleague and friend, Laura Tamblin-Watts, now with CARP, has characterized these three elements of practice in the following terms. Policy, what someone else wants you to do. Ethics, what you ought to do. Law, what you are obliged to do. In my presentation, I'm focusing on the law, but I encourage you to do your own research on other key sources of information that should be informing your work. And I just want to say a few words about the Canadian Centre for Elder Law. We are part of the British Columbia Law Institute, which is BC's nonpartisan, independent law reform agency, and also a non-profit agency, or I think in Ontario, folks usually say NGO. Our work includes legal research. So we publish a lot of studies clarifying the law, and some of them I will be referring to today, so you can do a deeper dive in learning around some of the issues I'll be talking about. Law reform work is a big part of our work, and that means we work with communities to develop reports making recommendations for changes to law, policy, and practice. And we work with governments that are interested in implementing our recommendations. As an example, and relevant to our discussion today, we are currently examining healthcare consent law in practice in BC in relation to older people living with dementia. Very soon we will be publishing a report with recommendations for law, practice, and education of the various healthcare professionals engaged in the work of prescribing medication or treatment, administering medication or caring for older adults or folks who are any other way involved in healthcare consent. Legal education is a big part of our work, and we've developed many tools to help folks understand the law, ranging from videos to fact sheets. I will provide links to some of those tools today. For example, on October 1, we are doing another free webinar on elder abuse and neglect. Outreach is also a big part of our work, so you sometimes will catch us in the media talking about legal issues that impact older adults, and we try to provide links on our Twitter and Facebook page for folks who want to check out those airings. Some of our work is national in scope, some provincial, some regional. It really depends on where the funding is coming from. I will say that I am a lawyer by training, and I've been practicing law in BC for about 20 years now, but I don't represent clients in the traditional sense that you're used to. So nothing I do looks like The Good Wife or any other TV program involving lawyers. In my presentation today, I am not going to be providing you with legal advice. I can't give you advice on what to do about your particular situation, but I'm always happy to direct people to other resources that can help you answer the questions you're dealing with, and sometimes to find free legal advice. So feel free to put a message in the question box or send me an email afterwards. My address is really easy to find from our website, which will be on the final slide of this presentation. So now to jump into more of the content here. In the last session, I emphasized that capacity is decision specific. So if you're wondering if a person has capacity, mental capacity to do something, you want to always ask capacity for what? What kind of decision? What particular decision is being involved? And get, really specific. If it's medication, what is the particular kind of treatment being concerned? You want to identify what data is relevant to making this decision. In other words, what does a person need to understand in order to make the decision at issue? A person does not lack capacity just by virtue of having a disability or a cognitive impairment. Everything depends on the abilities of the person, and every person is unique. And as I mentioned in the last presentation, many of our provincial statutes include presumptions that people have mental capacity at law, regardless of disability. Further, I would argue that the question is not strictly, can the person understand the relevant information in order to make a particular decision at issue? But can they understand this information if provided with appropriate support or accommodation? And I take this approach to mental capacity due to the impact of human rights law on mental capacity law. And I wanted to start out by talking about this point in the webinar today, because I think this is a kind of under-discussed component of mental capacity law. Often when lawyers are talking about mental capacity, we don't touch on the human rights piece. So when I'm talking about human rights law, I'm referring to both domestic and international human rights laws. So first to talk about—
Hi, Krista.
Yes?
Sorry, I didn't interrupt. You're just cutting in and out a little bit.
Okay, can you hear me okay right now?
No, so I only heard now and not part.
Okay, I don't know why that would be happening.
Oh, that's better.
Is my volume louder? Is that helpful?
Yeah, I think so.
Okay, so did folks get the previous slide, or did you just start losing me now?
Sorry, a little bit again.
Yeah.
Okay, so it might just be on my end. Somebody has, a few of the participants have messaged.
Yeah, I'm having trouble hearing you, but are you telling me that participants are saying they can hear things okay?
Yes.
Okay, so I'll just continue unless you interrupt me again or someone emails you to say there are problems. So we were talking about human rights law. In terms of domestic laws, what I mean is that every province and territory in Canada has a human rights statute that prohibits discrimination based on a list of grounds. Every human rights code includes disability, also race, sexual orientation, sex, etc., the usual suspects that you'll see in human rights laws. In Canada, judges have interpreted human rights law to require accommodation of people's disabilities to the point of undue hardship. Now, accommodation means adaptations or changes to policies, physical space, or other standards that create barriers for people with disabilities. And you can imagine that if you have a cognitive challenge and you're trying to make a decision, barriers could emerge in terms of the discussion of the problem in front of you. Now, the most literal examples of accommodation might be building a wheelchair ramp or providing a language interpreter. Provincial and territorial laws apply to businesses, governments, communities, landlords, employers, teachers, healthcare providers, universities. So it's a really big list. And there's a fairly good chance that your relationship with older adults, human rights law might apply to that relationship. In terms of international law, there's also a document I want to mention called the United Nations Convention on the Rights of Persons with Disabilities. Now, this law applies to bodies that have signed the document, so that's countries like Canada. It doesn't give you an obligation as an individual, but I think it's useful to know about the values embodied in this law and try to live them in terms of your work. The convention requires states to take appropriate measures to provide access to persons with disabilities to support that they may require in exercising their legal capacity, including support that will allow them to maintain decision-making autonomy, which is really relevant to the conversation we're having today. So the underlying question is, when you're thinking about capacity, is also, is there a barrier in some way to a person with a disability? Can you support the person with a disability to participate in decision-making through some kind of adjustment in your practice? In the last webinar, I provided some practical examples of how to support capacity, and I directed you to some of the tools created by the Alzheimer's Society of BC and of Canada. I'd encourage you to look for different resources that can help you to increase access to decision-making for people with disabilities. What does accommodation look like when we're focused on capacity, since it's not going to be a wheelchair ramp? If decision-making is at issue, it might be something like some of the examples I provide on the slide. So giving people more time, welcoming helpers or supporters who assist the person with disability, decision-making or their disability generally into the conversation, creating very plain language forms, making reminder phone calls if there's an ongoing process, booking meetings around health issues and medication needs and other things related to the person's cognitive impairment. Sometimes you may need to get the support of an expert to help you understand accommodation needs, especially if you're doing a large project involving diverse people with disabilities. I would encourage you in your work to always be creative and curious about accommodation, to ask questions, and to avoid assumptions about how disability and cognitive impairment limit ability, and instead focus on building on every person's unique strengths. As I pointed out during the last session, different capacity standards apply within the law to different types of decisions or activities. So this slide covers many types of decisions or activities that are subject to different capacity standards. So making a will, choosing to get married, making a decision about surgery, participating in mediation, signing a contract or other document, participating in a research project, making a power of attorney, getting a divorce, refusing treatment to medication or accepting treatment, giving instructions to a lawyer or other professional, choosing to sell real estate, making a decision about donating your money to an agency or gifting some money to someone in your family, appointing a supportive decision maker to help you with decisions, and we'll talk more about that today, making a decision about going into a care facility or not. So all these types of decisions have their own test, and it would be rare for a person to be so compromised in their capacity that they couldn't make any of these decisions. Some of these capacity standards are set by statute, so they're written up in a law. Some of them have been developed by judges in court cases. And the latter, those court case developed tests, we often call common law tests of capacity. So I will not be reviewing every capacity standard here today because that would take a few days at least. What I want to do is highlight some of the unintended consequences of the proliferation of very specific, diverse capacity standards. And so what can happen is someone can have capacity for one of only two related activities, and that can create some challenges. So I just want to highlight that for you today, and then I'll provide some further reading if you're keen to learn more about capacity standards. So on the slide, I mentioned three capacity standards and their relationships to another I want to just briefly discuss today. So consider, for example, capacity to marry or separate versus capacity to make a will. Really related activities, but different tests. So capacity to marry, separate, and create a will, they're all generally common law tests, although I think for wills, some jurisdictions are starting to create statutory tests. Although capacity to marry may vary slightly across the country, it is generally considered to have a very low bar compared to other tests, and in particular to capacity to make a will. I've heard one lawyer joke that basically all you need to do is be able to say, I do, when that question is posed to you. Do you take this person to be your partner? Essentially, a person must understand the social aspects of the contract of marriage, not the complex financial implications. A person has capacity to separate if they can basically form the intention to live apart from the person with whom they were previously married or in a common law relationship. As a result of this low bar, some critics have called for law reform to help protect people with mental capacity issues from what is called predatory marriage. It generally refers to marriage with the intention of acquiring assets, a sort of malicious intent associated with marriage. Predatory marriage is becoming a form of elder abuse that some civil litigators, particularly in the States, are seeing a lot more in their practice. Although capacity to draft a will is higher, in some jurisdictions, marriage will automatically revoke the will to provide some protection there. So a person can have capacity to separate or marry, but not capacity to change their will, even though those two actions seem fairly related, because judges have determined that the capacity for creating a will should be higher. Testamentary capacity is what this kind of capacity is called. And, a person needs to understand some pretty complex stuff, such as the nature and effect of making a will, the property being disposed, the people who will get property or might have a moral claim or entitlement to property, and how those assets are being distributed within their will. So it requires a lot more complex understanding. Now, a second example of where you could have two related but different capacities standards juxtaposed is care facility admission, so going into a facility, versus consent to health care within that facility. Care facility admission is generally considered to be a very complex question and often requiring a formal assessment of incapability. The issue often comes up if an older person with significant health or mobility issues wants to stay at home, but family or health professionals are concerned about the safety of that older person in their home. Family may be worried about falls. They may wish to require the person to move into a care facility against their wishes. And the older person may want to live at risk on their own terms in a family home. It's such a common desire among seniors to age in the home they've known for a long time. Even if the person is determined to lack capacity, care facility admission, so is required to move into a care facility, the person may still be entitled once they get there to make all or some of their healthcare treatment decisions within that facility. Under common law and statutes existing in some jurisdictions, read healthcare consent law, because many jurisdictions are governed by common law test for healthcare consent, but a few jurisdictions like BC, Prince Edward Island, Ontario have created healthcare consent statutes. Each treatment situation, so every time a healthcare provider is proposing a form of healthcare, it opens up the question anew. Does that person have capacity to make this particular healthcare decision about this drug, about this test, about this kind of therapy? So you always consider the capacity issue anew when you are giving someone an option of care. You're looking at what information applies to that decision? Do they understand the medical information? Do they understand that they have this condition that applies to them? Healthcare providers are obligated to go through this process. But what happens in practice is that some care facility staff mistakenly assume that older people who have admitted to a care facility have consented to all treatment by the care team or don't have the right to consent to care because someone consented to admission. This is an incorrect assumption, and it results in people basically losing their rights at the point of admission, which is very problematic. And as you can imagine, creates lots of frustration for older people living in care facilities. Now, as a third Example, let's consider a representation agreement versus hiring a lawyer. So generally you need to be able to sign a retainer to hire a lawyer, and that means kind of contract. And ethical rules restrict a lawyer's ability to assist a client who cannot sign an agreement. This is designed to protect people from signing agreements they don't understand. But the result of this and unintended consequences is that sometimes a person who lacks capacity to sign a contract needs legal help. So how can they hire a lawyer to get legal help? For example, they may wish to challenge the authority of a legal guardian that they think is doing a crappy job, or maybe they think they have capacity and should actually be allowed to make their own decisions. Or they may wish to appoint someone to make decisions for them on their behalf. In BC, for example, we have a law called the Representation Agreement Act that allows a person who doesn't have capacity to sign a contract to appoint a representative to make certain kinds of decisions for them or to help them make decisions. But the trouble is they can't hire a lawyer to get help with this decision. Or if they do hire the lawyer can't require a retainer agreement, so risks not being paid. So you can do this work as a lawyer, kind of volunteer, but you can't really sign that contract. In any event, this kind of legal conundrum that was not deliberate can create barriers for people with disabilities wanting to hire a lawyer and get some help. Now, if you're more curious about mental capacity standards, I'd encourage you to read a report by the BC Law Institute, which is my parent body, called Common Law Tests of Capacity. And I'll provide a link to their website on the final slide of this presentation. Now, I know I've talked about some of those complex differences in capacity tests, but the basic principle that I'm trying to make is that capacity tests are so diverse. And even though two tests might be super related, a person could have capacity to make one kind of decision, but not others. And that can create some challenges for people and some problematic practice within different kinds of facilities. So I encourage you to be aware of those kind of rights violations or access issues in your own work. So what if someone has some capacity issues, but still a fair amount of ability? In some provinces and in one territory in Canada, it is possible to appoint a person to provide support with decision-making. This person is called a supportive decision-maker, and the practice is called supported decision-making. Someone might want a supportive decision-maker due to disability, but you might just want someone for practical reasons, because decision-making can be very collaborative. The notion of supported decision-making is that a person retains their full legal capacity, which is different from if you have a legal guardian, but you can get support from someone who must be formally recognized by another agency like a bank or a lawyer or a doctor. The role of the supported decision maker is not set out in most legislation in Canada, and each supported decision maker relationship really is tailored to address a person's unique needs for support. However, for example, the Yukon has set out the following responsibilities in its law called the Decision-Making Support and Protection to Adults Act, and I think it provides some useful guidance. So you see on the slide, it says the responsibilities of a supported decision maker are to assist the adult to make decisions and express the decision. So it's making the decision and also communication. To assist the adult to obtain relevant information, so they can make an informed decision. To advise the adult by explaining relevant information and considerations, to ascertain the wishes and decisions of the adult and assist the adult to communicate them, and to endeavor to ensure that the adult's decision is implemented. Based on our own research, I would say a supported decision maker also helps others to truly hear or understand that person with a disability, to appreciate their unique needs, goals, preferences, and to respect the person's autonomy, dignity, and wisdom. And really underlying these kind of goals is to help prevent discrimination based and bias linked to disability. Often we have unintended sort of ageist or ableist assumptions about what people with cognitive impairments are able to do. The concept of supported decision-making is grounded in the notion that interdependence is the normal way decision-making happens. Very few of us make decisions in isolation. Most of us trust somebody and talk things over. But most of us although most of us may do this, for some people living with disabilities, supported decision-making can allow them to be engaged in decision-making in a way that otherwise wouldn't be possible for them because they have more dependence on support in order to be able to have their autonomy be recognized. There's a good chance you haven't heard of the word or term supported decision-making because it's not available in all provinces or territories. And in fact, when we've consulted with people in community about supported decision-making, what we found is that a lot of people do it without using that word. So there are arguably 5 jurisdictions that have created laws that mention supported decision-making. They are BC, Yukon, Alberta, and Saskatchewan, although I would say that Manitoba references it in this law called the Vulnerable Persons Living with a Mental Disability Act. There's not really a framework for supported decision-making created by that law, so I would say it's not really a supported decision-making regime. So the four jurisdictions where you need to be aware of supported decision-making, if you work in these provinces or territories, are BC, Yukon, Alberta, and Saskatchewan. And I want to tell you about a few things about each of these regimes because, just to be confusing, it's kind of different everywhere, although ideologically we're talking about the same things: help with decision-making and recognition of those helpful relationships. The details are quite variable. So BC, we have a law called the Representation Agreement Act, which allows a person, even someone who doesn't have capacity to sign a document or a contract generally, to appoint someone to assist with some decisions without the court being involved, without a guardian being involved. And these agreements can cover a lot of stuff like personal care, routine financial affairs, healthcare decisions, and some legal matters. The person is called a representative, and you can choose this person and appoint the person without a lawyer or with the assistance of a lawyer. There is some confusion because under this law, you can create someone to make decisions for you or make decisions with you, and it's still called a representative. So if someone says they have a representative, you really want to look at that document or ask them questions to find out, is this a supportive decision maker or a substitute decision maker? Now in the Yukon, there's a similar kind of person that can be appointed under agreement for supported decision making, but they call this person an associate decision maker. The same law also allows a person to be appointed called a representative, and they are a substitute decision maker. So again, terminology is not consistently used across the country and can be confusing. In Alberta, their Guardianship and Trusteeship Act creates 2 different kinds of supported decision makers. One is called a supporter, and one is called a co-decision maker. A supporter is created by agreement, by a document, as you can do in BC and the Yukon. And it's called a supported decision-making authorization, but a co-decision maker can only be appointed by court. Again, please don't feel you have to memorize the stuff. You've got the slides, but I think the important point is that there are some subtle distinctions. Now, I mentioned Saskatchewan. They have someone called a co-decision maker, and that's ostensibly supposed to be a supported decision maker. But please be aware that if you look at the legislation, the arrangement can only be put in place by a court order, and it's not clear that even that person with a disability can apply for the court order, or maybe just other people. So it's not, I would argue Saskatchewan's regime is not really true supported decision-making because it's not really chosen by the person with the disability. So that is all I'm planning to say today about supported decision-making. I think it's important to be aware that these 4 jurisdictions, or maybe just 3, make supported decision-making available. Different words mean different things. Now, if you want to know more about supported decision-making, please look at, there's a paper we wrote which compares the law and gives you some tables to help you understand the differences. It's called Understanding the Lived Experience of Supported Decision-Making in Canada. It's available from our website. And again, I'm going to provide a link to this paper at the end of my presentation. Based on our research related to a number of projects, knowledge of supported decision-making is really limited across Canada, but it's an excellent option for some people, especially people with cognitive challenges. And that's one of the reasons why I want to mention it to you today, so you can be aware of it and encourage people to find more information about it in case it's an option available to them. And for example, there's some ethical issues that could emerge. For example, so in the Yukon, if somebody has a supported decision maker, but you don't consult them and you get a person to sign the agreement, the decision could be void. So there can be some legal implications of not consulting a supported decision maker, making it all the more important to be aware of supported decision making. Now, another kind of decision maker is a substitute decision maker. And there are basically 3 different ways that you can get a substitute decision maker. One is they could be picked by you, appointed by you, and they get their power through a document. And a good example of this is a power of attorney. Secondly, they could be appointed by a court. So usually they're called a guardian. In BC, we call them committees. Or they could get their authority by way of a statute, some kind of statutory process. And I want to say a few words about each of these examples. The concept of modern substitute decision-making, although in practice, I think some people feel like it's not really advancing their autonomy because somebody else gets to make decisions for them. However, the principle of decision-making, the goal of modern substitute decision-making really was to protect people's autonomy. And this is because notionally the person who's making decisions for another is sort of stepping in their shoes and trying to exercise their will for them in a way that they can't anymore because of a cognitive impairment. And as a result of that, as I'll discuss in a moment, there are some duties built into the role of different kinds of substitutes to make sure that people are respecting the wishes of what people would have wanted or what's in their best interest. The most important thing to be aware of is the guardians don't just get to do whatever they want, or substitute decision makers don't just get to do whatever they want, although unfortunately some folks think that because there's not superb education of substitutes out there. Substitute decision making, like capacity to consent law, is created by provinces and territories. And so you have slightly different regimes in each jurisdiction, and sometimes things are called different things, as is the case with supported decision-making. So some kinds of substitutes are chosen by us, and the best example, I think, is a power of attorney. And you might choose someone by way of a kind of advanced planning for the future, especially if you have a disability, and you want to choose who's going to make your decisions rather than having it be chosen by a judge or decided by a judge. So it allows you to have some control over decision-making in the future by choosing the person you trust. And the word power of attorney is what you'll hear most of the time for substitute decision makers, although, as I've just mentioned in the previous slide, in BC and Yukon, the term representative is used for some kinds of decision makers. Although the word attorney is used, the substitute doesn't have to be a lawyer. It's really just someone you pick whom you trust. Usually folks appoint spouses or adult children to be their attorney. The document is called the power of attorney. The person is the attorney. And it's really important if you're dealing with an attorney to be aware of scope. And the scope will depend on the legislation, which sort of sets out how their scope could be limited, and also the specifics of that document. And a very important difference to be aware of is that in Ontario, you can appoint an attorney for personal or healthcare decisions, or an attorney for like financial or property decisions. But in many jurisdictions, a power of attorney can only cover financial, legal, or property matters. So it's really important to be aware of where was that document created and what is the scope of authority. Sometimes people who hold that document misunderstand their authority, and it's not an uncommon situation in BC for someone to show up at the emergency room and say, I'm entitled to make decisions for my father, and waive the power of attorney. And as we've just discussed, in BC, a power of attorney would just deal with financial decisions, not healthcare decisions. So substitutes can also, bullet point 2 here, get their authority by the court. And this would usually happen as a result of an application by an individual or by a public guardian or some other agency. Usually there would be a formal incapability standard embedded in the legislation and a formal incapability test or assessment undertaken by a professional. You can't generally get a guardian without a process involving court, although there's some exceptions across the country. In BC, I said we confuse people by calling a guardian a committee in our law. Now, some substitutes can get their authority via a process created in a statute that doesn't require a document or a court process. I'm just going to give you a couple examples. In BC, you can now get the PGT, the Public Guardian Trustee, can get authority as a property guardian. So just financial and property managers without going through a court process. In some jurisdictions, healthcare consent legislation allows the healthcare provider to choose a temporary substitute decision maker to make healthcare decisions for a person who cannot consent and doesn't have a guardian or other representative. So the situation I just mentioned where the person is in emergency, unconscious, and that someone's waiving a power of attorney. It's not the power of attorney who would make the healthcare decision. The healthcare provider would choose someone from a list of family members. And generally the default list in healthcare law starts with the spouse, then adult children, and if there's no one else, it might be the public guardian, but again, this is not the case for every jurisdiction in Canada. A small number of jurisdictions have healthcare statutes. So you always need to be aware of what is the law in your community. There is a very sort of egregious exception and in BC as well, under the Mental Health Act, the director of a designated facility is deemed to provide consent to psychiatric care for a person who's involuntarily committed under the Mental Health Act. This is a unique provision in Canada, but just to be aware, mental health law creates different kinds of rights in BC. So substitute decision-making authority, there can be different kinds of authority. And so documents or court orders should indicate how specific that authority is. The authority could include healthcare, personal care, financial matters, property transfers. Generally a power of attorney that allows for real estate transactions requires some extra steps. You could have authority for care facility admission. Authority depends on the type of legal document or the court order. Now, as I mentioned earlier, substitutes are not entitled to do whatever they want, but sometimes they think they do. And we'll talk about elder abuse through a substitute in a moment. But just for now, I want to mention that in addition to having to stick to the scope of authority in the document or the court order, substitutes have other duties as a result of the operation of this general common law and also specific statutes. So this slide provides some examples. There's generally a duty to keep records or act honestly for some kinds of decision makers, particularly guardians, but the statutes can also create specific obligations around keeping records, acting honestly. Some substitute decision makers have an obligation to consult with the person they represent. Generally, guardians have a fiduciary obligation to consider best interests. At the extreme, in terms of obligations, consider, for example, a representative in BC. So this could cover healthcare, personal care, or financial legal decisions. The representative has a duty to consult to a reasonable extent with the adult to determine his or her current wishes, even if they have very limited capacity, and to comply with those wishes if it is reasonable to do so. So guardians or substitutes can have some pretty significant obligations. And these kind of provisions effectively protect the right of the person who may have compromised capacity to still be engaged in the decision-making process, even if they might have very limited independence or capacity to make decisions all by themselves. Generally, most importantly, vis-a-vis the use of money and assets, in the case of a guardian or an attorney, the substitute decision maker cannot use the funds for their own benefit. Many of the stories of elder abuse and neglect that we hear about at the Canadian Centre for Elder Law have to do with substitutes using funds for themselves. And this brings me to a brief discussion of elder abuse and substitutes. So many kinds of elder abuse are perpetrated by people the older person should have been able to trust. They are a breach of trust or an abuse of authority. Some crimes in the Canadian Criminal Code exist to address these kinds of abuse, regardless of the age of the victim. And this slide provides some examples. So a very specific one is theft by a person holding a power of attorney. The attorney who fails to fulfill their duties breaches provincial and territorial law in terms of legislation governing powers of attorney, but they also could be committing a crime. And honestly, a lot of police officers are not aware of this provision. They think they might, if they're not specialized area of practice dealing with elder abuse, they might think that it's just a family matter or a civil issue, but theft by a person holding a power of attorney is a crime. Sometimes officers need to be reminded of this. Neglect by a guardian or attorney is unfortunately not uncommon. Sometimes a guardian will be unwilling to spend the older person's money on their needs. Healthcare needs can be neglected, bills not paid, service is not accessed, and often in the name of protecting inheritance funds that people think they're entitled to. This is abuse, and it's also possibly a crime. A guardian can be prosecuted under a provision called failure to provide the necessaries of life. And this is, it's not called neglect by a guardian, but this kind of provision could cover neglect by a guardian. Usually people only get prosecuted in really extreme cases of neglect, but it is a relatively underused provision that could be used to protect older adults. And if you want to know more about abuse and criminal law, we have a paper on our website called the Counterpoint paper that analyzes quite a few cases. You might find it interesting. It's available on our website. Threats and intimidation. You know, often we think that these are just mean things people do, but actually they're criminal acts. And older people often sign over decision-making authority as a result of some kind of threat or extreme pressure. And in a previous presentation, I called this undue influence. And the following slide, I have a picture of the cover of our undue influence reference aid, because I think it's a very useful tool for people working with adults to help them better understand situations where older people are being pressured to do things that they don't want to do. You can link to this from the BCLI website, as all other tools that we and papers that we've produced. So some kinds of abuse by a substitute decision maker reflect malice and greed, right? At other times they reflect sheer ignorance. Substitute decision makers do not get lessons in what their job is, but they wield a great deal of power and sometimes have a pretty high sense of entitlement over money that doesn't really belong to them yet, at least while the older person is alive and the will hasn't been probated. So people who are attorneys under a power of attorney are often just regular people like you and me who, you know, our parent appointed us, but nobody gave us lessons in how to do this job right. And so people make mistakes because they don't get it, or sometimes they're greedy. In any event, you can encourage people to get information on their rights and responsibilities as substitute decision makers. Most provinces and territories, probably all, have a nonprofit or government agency that's developed an excellent brochure guide to help people understand their duties as a guardian or an attorney. And this slide here provides 3 examples of helpful websites, but many other sources of information exist out there in internet land. So what can be done if you're concerned about an older person whose substitute is abusing authority or harming an older person or stealing their money? The older person may be able to revoke the authority, like rip up that power of attorney. It's usually worthwhile for them to get legal advice about taking this step, and often free legal advice from a nonprofit could be available, but usually it involves destroying the document, contacting key third parties like the bank, and possibly helping the person to pick someone who is more trustworthy. Many older people do not realize they can revoke things, which means cancel the agreement granting authority, as long as they still have adequate mental capacity. Secondly, the court might be able to appoint a different guardian. This can be an expensive route, but it might be an option. Third, there might be an agency able to step in to assist. For example, the public trustee might have some authority to act quickly, protect assets. The rules are different in each province or territory. In a few provinces, elder law clinics offer advice and assistance to older people who are being abused or neglected. I would encourage you to check out the website of the Canadian Network for the Prevention of Elder Abuse. You can see it on the final slide of this presentation to find out where to get help in each province or territory. Now, I mentioned criminal law on the previous slide, and certainly a person can be prosecuted for a crime that is linked to elder abuse by a substitute decision maker, but often older people are reluctant to prosecute. However, some communities have very helpful elder abuse police units that will attend the older person's home and problem solve. I understand that much of what these elder abuse units do is social work, which is very helpful. And often the team will be an officer and then a counselor and a social worker. And even if the person doesn't want to lay charges, these officers have specialized experience and can be a great resource in helping an older person figure out what to do and helping them connect them to other resource agencies. So in terms of elder abuse response, when substitute decision-making is involved, the most important things to be aware of are, I think, be aware of signs of abuse or neglect, such as fear, unmet needs for nutrition, clothing, health, loss of sudden funds, and confusion about money. I'd say be a good listener, be available but not judgmental. It can take time for the whole story to come out and a lot of time for people to decide to take action. Help the older person to access support and information about their rights. Help them make the phone call, but don't take over. Let them do what they want to do. It's really important to respect rights and not infantilize older people or take away their power. Getting back to my earlier points on human rights law, you want to support them to have as much agency and capacity as possible to make their own decisions, both about the substantive transactions we talked about earlier, but also about the different decisions in their life in terms of getting help when they need it. So today we've covered a lot of ground. We have discussed different mental capacity standards, the relationship between human rights law and mental capacity, the meaning of supported and substitute decision-making, different ways substitute decision makers can get their authority, and elder abuse by a substitute decision maker. Each of these topics could have been a presentation on their own, and the session is intended to really introduce complex legal topics in order for you to identify issues more effectively in your own work. I wouldn't expect you to have memorized everything that we've covered today, but this session has been recorded by AgeWell, so the link should go up shortly and you can review the presentation at any time. Most of the subjects that we've discussed today are governed by provincial and territorial law. And I've tried to identify principles that apply across the country and illustrate some key differences. I encourage you to review the legislation, the right legislation that's relevant if you're looking at a problem, or even to talk to a lawyer or an advocate. The reality is now that laws are pretty accessible online, and a great resource that's free is called the Canadian Legal Information Institute. It's the first bullet point here, canley.org. You can go into select the province or territory, select statutes, and then go through alphabetical lists and find basically any law in the country. Some laws are actually fairly easy to understand and read. Some of them are short, some of them are long, but you may find looking at the law is actually helpful to understanding the problem. All of the reports from the BCLI that I've mentioned on mental capacity, on supported decision-making, on elder abuse, they're all available for free on our website. So you go to bcli.org. And then we've talked about elder abuse in the last few slides. If you want to learn more about elder abuse resources in your community, I encourage you to check out the cnpa.ca website. It's a great resource that's updated regularly to make sure there's information that's helpful to you. So that is what I'm wanting to cover today. And thanks for bearing with me. I know it's a lot of content, so I hope you feel like you've learned something. You can feel free to email me after if you want more information about a topic. I can link you maybe to some resources that could be helpful.
Okay, well, thank you for that, Krista. if anyone has any questions, we're coming up on the end of our time, but I'm happy to answer any quick questions. If you just want to write them in the chat box, I will then narrate them and Krista can answer. But as Krista mentioned, this was a lot of content. It was great content. And if you can't think of a question that comes to top of mind now, that's okay. You're always welcome to email us here at the office, or you can email Krista directly at the coordinates she provided in the webinar. So it doesn't look like anyone has any questions. I think this was information that needs to be digested, and then maybe someone will come back with questions later. Krista, did you have anything to add?
No, it's a lot of content. In some ways, there's no way of making it super simple. So I encourage you just to try to take home some of the basic concepts, and then the other resources I linked to should be able to help you, digest things further. And there's no, unfortunately, because we are national, there's no substitute for trying to find out the law in your own jurisdiction. But there are great locally based organizations that can provide you with specific information and brochures and fact sheets on their laws. And other examples are the Advocacy Center for the Elderly, the BC Center for Elder Advocacy and Support, CLEO in Ontario, Click Law in BC, the Adult Protection Unit in the Yukon. Like, a lot of these organizations have great websites that provide lots of information on their topics, and will give you something specific about your own province or territory.
Okay, perfect. So, so I do have one quick question. So there's a question about capacity and consent in research specifically. So I'm guessing they mean about, if you, like in the Age Well Network, we do quite a lot of research. Well, all of our research is based on older adults. So getting consent from someone who's older and maybe has, like you spoke about, the power of attorney and things like that. Do you have any language or suggestions around that?
Sure. And I think I know what Leslie's getting at in her question, because what often happens is that people with some cognitive impairment issues or even dementia get excluded from research because of assumptions about their ability to participate. And like a lot of the topics I talked about today, there's not a national answer to the question about capacity to participate in research. So as I mentioned before, there are about five provinces, territories that have their own statutes that cover healthcare consent. And some of them cover healthcare related research, but not all of them. The general question about consent to participate in research will also relate to policy. So as I mentioned on an earlier slide, there are policies. And I think if you want to take a look, Leslie, at the PowerPoint for Mental Capacity 1, I linked to a policy that relates to participation in research and ethical issues that most universities have subscribed to. So that'll be one consideration that folks will want to be looking at in terms of capacity to participate in research. We are actually doing a presentation. Alzheimer's Society BC for the Canadian Associated Gerontology Conference in October has a whole half-day pre-day on capacity participating in research for people living with dementia. If you look at their website as a pre-day, you'll see a link to that. If you happen to be in BC, you could register for that pre-day and participate in that session. There may be papers presented as part of that session that will be disseminated after that event. But there should be more information to share on that issue. I know that Jim Mann did a presentation on this topic at a conference in the spring. And that, I will see if I can find that link to his presentation as well. And if I can find it, I'll put links on that in my Twitter feed, which is CC Elder Law. So you can check it out later. The conference, I see your question. The conference is not an Age Well conference. It's a Canadian Association of Gerontology conference. I believe it's the 18th to the 20th of September, and the pre-day, which is the 17th or the 18th, has a half day sponsored by the Alzheimer's Society in BC. But if you go to the Canadian Association of Gerontology website, you'll find the link to more information about that pre-day on participation and research.
Okay, perfect. So I think with that, we will conclude the webinar. Krista, thank you so much for both this part 2 and part 1. It was really informative. And as Krista mentioned, we are recording this session, so it will be available on our website next week. So you can always feel free to go and check out all of our archived recordings of our webinar series. So thank you so much, everybody, and I hope you have a good day.
Thanks, everyone.